Hello, everyone. Yes, let's start recording. Thank you, Athrea. Hello, everyone. My name is Carla. I'm the Judith Bresler Fellow at the Center for Art Law. It's my pleasure to welcome you here. So good morning, good afternoon, good evening, depending on where you're streaming from. Let me just share my screen so we can begin. Sorry about this technical mishap. Before I hand it over, so welcome to our Ars Longa Vita Brevis workshop on best practices for legacy and estate planning. We're very excited to have Minerva Pinto here with us today. But before I hand it over to her, I would just like to take a moment to talk a little bit about the center and the work that we do. In the meantime, if you could also, we will be sharing a brief poll for participants. It should be popping up in your screen in just a bit. So please also take a moment to tell us a little bit about yourself as well. The Center for Art Law is a Brooklyn-based research and education nonprofit. We are dedicated to offering resources and programming to advance the arts and law community. So through our website, newsletter, events, we disseminate information and update our audience on everything art law, whether that be news, programs, cases, publications, and a lot more. We also facilitate conversations and learning opportunities such as webinars, clinics, and workshops like this one. We have plenty of events planned for the upcoming months. This Thursday, we will have a showcase on our looted art project. And next week, we will be having a legacy and estate planning clinic where artists and other interested parties like heirs and estate administrators can attend a keynote speech and also have 20-minute consultations with attorneys, appraisers, and other professionals. We also have this clinic format for other topics like copyright law and artists and dealers relationships. So keep an eye on our website, which is where we post we post all of our events. We will also be having an event on ethics, arts and the environment, and many more. To learn more, as I said, keep an eye on our website. Follow us on our social media channel. You can see the handles on the screen. Our newsletter in particular is a great way for you to learn more about not only what we offer, but art law news and everything else related. So please, you're welcome to join. You can do that through the website. And if you already know our work and love what we do, you consider donating or even becoming a member. Memberships are discounted for artists and students. It allows you to access discounted tickets to our events, past recordings as well, and our case law corners for those in the legal profession and any other benefits. So before I hand it over to our speaker, just a few housekeeping items. This workshop is being recorded. You will receive a link to the recording after the session. We will also be sharing in the chat a handout with you. It will also be delivered after the session, another copy where you can see our presenter's full bio, also additional resources in case you're interested in learning more. And if you have any questions during the presentation, please post them in the chat box. We will address them at the end of the session. With that being said, I'm very happy to introduce our workshop speaker, Minerva Pinto. Sorry. Thank you so much for being with us, for teaching this. We know you're in a busy week, so we are very excited to have you here. Minerva is an attorney and also currently art and collectible strategist and trust officer at Goldman Sachs. As I said, her full bio can be reached at our handout, and I will stop now sharing my screen so I can hand it over to you, Minerva. Thank you.
Great. All right, let me do the usual dance to share my screen. Sorry, let's move this around. All right, so hey everyone, thanks for taking time out of your day, your lunch to tune into this presentation on estate planning and some tax considerations for visual artists and their estates. Of course, I'd like to thank the Center for Art Law for asking me to present on this topic. I've been really passionate about it for my entire career, so maybe about the past decade or so, and I'm always looking for outlets to kind of share this information with all of you. For those of you encountering me for the first time, my name is Minerva Pinto. And as Carla mentioned, I'm an art and collectible strategist and trust officer in the Goldman Sachs family office. For some background, the Goldman Sachs family office exists to help client with the non-investment related issues that really keep them up at night. And so, income and estate planning and art and collectibles are among those. I've been here at Goldman for about 6.5 years now, and I split my professional time between Boston and New York. And prior to my time here, I practiced intellectual property and licensing law at a firm in Philadelphia, where I also got additional exposure to this sort of niche intersection between trust and estates and art at the Barnes Foundation, Freeman's, which is now Freeman's Hindman, and the Philadelphia Volunteer Lawyers for the Arts. I wanted to start out by saying that I've worked with all kinds of clients, artists in this case, with all kinds of backgrounds, career trajectories, financial and familial complexities, and I've really found the estate planning process to be the great equalizer. And that's not to say that there's a one-size-fits-all approach to legacy by any means, and everybody should and does have their own vision for the mark that they want to leave on the world and on their loved ones. And what I mean really when I say that estate planning is a great equalizer is that the questions that you should be asking yourself over this process and the best practices that you should be incorporating over your lifespan are really the same for everybody. And sort of, maybe the plan that you're implementing them for is different, but really we're all sitting here contemplating those deep, dark legacy questions. And we really all need to get organized. And it really brings even like the largest, most established estates kind of down to their knees. So what I'm going to do today is kind of work backward. And what I hope to achieve by this is so you can start to piece together yourself why the best practices that we kind of find tedious and daunting and maybe you find unnecessary are in fact beneficial to you and your legacy and those you leave behind. So that kind of means we're going to start with the maybe scarier, drier stuff first. That's the death, the taxes, and all the things we don't want to think about. And then I'll get into some ways along the way that kind of make them less scary and easier to deal with. So I don't even know. Here we go. Okay. So what happens when we die? Well, I know that like many of our best and brightest minds over the course of thousands of years have really tried to think about what happens to us when we die. And luckily the IRS has stepped in and let us know that we in fact become an estate. Um, and an estate is essentially an inventory that's taken by an executor to facilitate the deceased estate plan after after debts are paid and any taxes are levied. The estate of the average person really usually just contains some bank accounts, financial assets, real estate, maybe a car, a bike, and a whole host of personal possessions, which I've listed here as, furniture, electronics, heirlooms, artwork, jewelry, etc. All of these assets are located, aggregated, and valued, and then the estate will, the executor really, will file the final income tax return for, the portion of the year that you were still living, and then to the extent necessary, any estate tax returns. I would like to sort of caveat the fact that, really estate tax returns are really only required for larger estates, and both state and federal governments are interested in the size of your estate. So for the federal government right now, you don't really enter this gnarly world of estate taxes unless you as an individual, and it's larger if you're married, is around $13.6 million. States have different thresholds, but it still tends to be rather high. And so you really don't need to be worrying about the estate tax part of it. And if you do, you really need to start getting on the estate planning front now. Of course, the more you own, the harder this inventory is. And if assets are scattered around the world or scattered anywhere, or they're not even identified, then this process becomes even more complicated. And luckily for artists, a lot of their estate is already among these assets. So in addition to the assets that are owned by the average individual, there are some unique considerations to take into account when we're taking a bird's eye view of an artist's estate. Of course, we have here the artwork itself, which in many ways poses the largest challenge. works are often scattered across a variety of locations. For practicing artists, that can be your house, your studio, whether you can assign them to one or more galleries, if they're held in storage, if they're on loan at institutions, if for some reason they're, being transported, or, maybe you've loaned them to a friend, or they could be anywhere. And the volume of those materials can be quite high. I mean, when you think about the career trajectory of an artist, they've made, I think you guys know better than me, thousands of works. And so knowing where all those are, and keeping track of them is complicated. Inventorying that work is time consuming and imperfect. And without adequate records, it's really hard for an estate to accomplish that. So believe me, we're going to talk a lot about inventorying throughout the course of this presentation. Suffice it to say for now that that's probably the tedious, daunting task that I was alluding to a little earlier. Next, we have intellectual property. In this context, it's going to be primarily copyright associated with the physical or the digital work in question. And I know the Center for Art Law has produced umpteen number of presentations on copyright, so I'm not going to get too deep into it. But IP exists distinctly from the artwork itself. So just because you sell a work of art doesn't necessarily, it does not, unless expressly stated, mean that you've sold the copyright to that work. And I think maybe sort of the most important bundle, right in that bundle of copyrights is the right to reproduce. So how you manage your copyright, or sorry, how you manage your copyright is really important when you consider your legacy, especially considering that the standard term for copyright is the life of the artist plus 70 years. So if you're able to generate royalties and revenue from your IP, that's something that your family and loved ones can continue to use as revenue. And so it's an important planning tool if that's how you're using it. It's also important to remember that you've maybe granted IP licenses throughout your lifetime. And so just understanding the scope of those licenses and whether or not they terminate when you die, for instance, is also important. So it's real, we'll get a little bit more into agreements and things that you want to keep track of later, but understanding how those play into your death and what happens afterwards is also something that needs to be tracked. We also have archival material here, which is, exhibition material, sales records, sketchbooks, other documentary information that may provide context for your work and practice. I also have here tools and supplies, which I know we've walked into Blick and we know that they're valuable. That's all I'm going to say there. But those may be valuable to a beneficiary or someone that you may want to leave it to, and you don't want it to end up in the garbage. So those are also tracked and managed. And then finally, I've listed here contracts and business interests. And, some artists formalize their practice more than others, but understanding the scope of any of those contracts that you've created or business ventures that when you're working with other people, are also things that may be considered in the asset bucket, or things that at least need to be understood by your executor. And then, like everything in an estate, these unique assets need to be valued. And needless to say, any of these is not as easy as just logging into your bank account and seeing what the number is at the end of the ledger. I know that many of you are intimately aware with the idea of an appraisal, and likely know that this is a more subjective, multi-factor process. These also change over time, so we always recommend regular appraisals when necessary. But we really take into appraisers take into consideration history of sales, the current contracts, condition, comps, any number of factors to determine a fair market value. And then those are considered when assessing the gross value of your estate. IP, again, is separate from the work itself. There are, a similar methodology is used when appraising IP rights, but it is important to understand that it is separate. I also have a note here about block discounts and the death bump, just because it does come up, especially for more established estates. The blockage discount is a discount that appraisers may apply when valuing work. If you have, for instance, a large body of work by an established or an artist with an established market, and they know that if they've made a plan, for instance, to sell all their art upon their death, there's a discount that's applied because the market recognizes that there may be a depression in value if you flood the market with someone's work. That's not something that's recommended anyway. And we'll talk a little bit about that later. But appraisers can apply blockage discounts to account for the fact that liquidity of that piece is not going to be necessarily immediately available, and if it is, it's going to be lower. Finally, I have the death pump here, which is kind of both a myth but also real. We kind of have this thing we talk about a little bit about, inexperienced collectors who go to the cruise ship gallery and buy a work, and people have come to us saying, hey, I bought this piece, but the artist just died, and so therefore it's going to be really, really high, for these valuations are going to go up. And that's not necessarily the case. That's really in an established artist's market, and it's usually somewhat temporary. It really just has to do with suddenly the supply of that artist's work being capped and people wanting to get it while they can. So I wouldn't let that affect valuations too much, and I wouldn't get too excited about it. Again, all this, by the way, is just at the inventory stage. So I hope you're starting to maybe be able to visualize how you can start implementing some practices to make this all more manageable. I am going to give you a quick rundown right now, though, just of some best practices. So in my opinion, so much of what makes the estate settlement process run more smoothly for your executor is the same practice that makes your lifetime business healthy, regardless of whether you're a full-time creative or if this is something that you kind of do on the side in a robust way. Of course, the sooner that you incorporate these habits into your practice, the less daunting it will be. But I really think that these are good, both business practices as well as good ways to prepare for estate settlement. So keeping a running inventory here of what you've produced, as we've already talked about, is really important and does serve a number of functions. Like I said, it is a good business practice. Some artists don't really like to think of themselves as small businesses. And the fact is that you are. And the fact is also that no good business runs without books and records and an inventory. I was even on my way in, I noticed that even my local cheese shop is closing early today to conduct scheduled inventory, and it's just a fact of life in a business. It's also invaluable for your executor, who's going to need to rely on your knowledge when you pass. An executor is not able to divine where all your work is located and what you've created. I mean, this is a massive amount of work, even for the average person, so a non-artist. So in addition to keeping track of the work that you've created over the course of your lifetime, I would say that it's a good practice would be to keep track of the location of your works. So as I mentioned earlier, work can be scattered across a number of locations just by virtue of your practice. So your home, your studio, if it's on consignment somewhere with the gallery, if it's, in your basement, it's just good to keep track of where it's located at any given time. Finally, or not finally, we have a lot more to go. If work has been sold or gifted, it's really important to keep track of who's received what, if it's been sold, to the extent that you have access to any invoices or records, I would keep track of that. As we've mentioned before already, how work has sold is considered in the appraisal process. So anything that you can keep there would be helpful also with that. I like to think of this as kind of creating your own catalog raisonné for provenance purposes. It's easier to do it yourself and put your stamp on it than it ever will be for someone else to do. I've included the cost of materials here because if you are looking to donate your work to a cultural institution during your lifetime, that will be what the deduction that you can get is based on. You're not going to be able to deduct the full fair market value for it. Artists are limited to cost of materials. So if you do envision gifting work, keeping track of that and the cost of production is going to be the information that you're going to rely on. Of course, photos are great. I recently was gifted work by a family friend who's been a practicing artist for decades, and she had forgotten to take the photos and asked me to do it. And I was just very proud to know that she has that as part of her practice, because that's really, really tidy, I think. Next is to keep track of all the agreements that are, related to your art practice. I've listed here gallery representation and consignment agreements, loan agreements, IP licensing agreements. Again, this is an important lifetime practice generally, but also incredibly important for understanding whether these agreements have any after-death implications that your executor needs to know about. In other words, these agreements may not necessarily terminate on your death, and that will be that the executor will need to factor that into the long-term estate settlement process. Similarly, if you're collaborating with other artists or organizations, you definitely want to keep those agreements. And whether it's uncomfortable or not, it's really important to clarify ownership of any work if it hasn't been sold or used, and intellectual property ownership. That's usually a lot easier to manage upfront than when there's a tiff about it. So I really strongly recommend that that's clarified upfront and documented. I think it kind of goes without saying that maintenance and storage is important. If you plan to bequeath or donate your work, you want it to exist at the time that it's bequeathed or donated, and you want it to be in as best condition as possible. So you want to continue that throughout the course of your lifetime and sort of make plans to the extent that you don't already about where it's going to be stored and during the estate settlement process. Some artists should also consider a conservation plan. We've worked with artists in the past who say that they want to be the only ones who conserve their work, and if they're not available, then these people are, or things like that. Just it really depends on your practice and your personal preferences. Insurance kind of dovetails right off that. You want you and your beneficiaries to not be like SOL if your studio floods or something really awful happens. And there's also going to be that limbo period between your death and when the works make it to their final destination in terms of beneficiaries. So just understanding the scope of your insurance policies and those kind of worst case scenarios is going to be important for your executor to know. Maybe they need to make plans or not. Just good to keep in mind. And finally, just briefly on the topic of copyright, you have copyright immediately upon the creation of your work, regardless of whether or not it's registered with the Copyright Office. However, there are additional protections that filing your copyright gets you that makes it a lot easier to enforce in the event of any copyright infringement during your lifetime or after your death. If you have an estate plan that relies heavily on continuing to receive royalties, I strongly recommend registering with the Copyright Office just for maximum protection. The USPTO would be the appropriate body for trademarks and patents. This is, like I said, this is like the daunting, not fun part. You'll hear of established artists having like studio assistants, and maybe they're helping with creating the works themselves, but this is obviously the kind of management and administrative tasks that those people carry on. There are collections management professionals in the space that take on these functions as like a project basis, whether it's for hourly rates or on a retainer for artists and collectors who don't really have the resources to keep a staff. So I think that those are really incredible resources for artists maybe who don't have massive estates and the ability to pay people every single day on a salary. All right, so I'm going to start moving on to a high-level overview on legacy vehicles and the tools that you can use for estate planning. Much like everything in this presentation, solutions for every estate need to be tailored to your specific goals and needs with a lawyer or another professional. So I'm not going to be making specific recommendations apart from saying that I strongly advocate for having a plan, period. We don't intestacy, this first bullet here is really not the safest way to go. And I don't think in the context of a conversation of creating your legacy, it really does anything for anybody. So like I said, intestacy is the official term for dying without having a written will or a legally effective plan. What happens when you die intestate depends usually on the state in which you were domiciled at your death. There are assets like real estate that pass in accordance with the state in which the real estate is located. So if you think of a vacation home, or maybe if you have a studio in another state, um, that may not necessarily fall in the same way that your domicile state does. And when you pass intestate, there are state laws that kick in that allocate your assets in accordance with this default plan. And that's usually by finding your immediate family and portioning it in some prepackaged way. And then if you don't have immediate family members who are living or who existed, it looks for more and more remote relatives. And if they don't find a remote relatives within a certain, distance, your assets, it's called a skeeting to the state, which is really the worst case scenario in that your entire asset goes to the state. So like I said, it's extremely rare. But like I said, in the context of crafting a legacy, that's not what anyone wants. So a will here is the tool that I would imagine that most people are familiar with, and that really everyone should have at minimum. As bare bones as this document can sometimes be for really straightforward situations, it's really important that you remember that every single state has different rules for what constitutes a valid will. So you want to just make sure that you're not like going to your computer and typing something up and printing it out and leaving it in your desk, because that's where the problems start. Keep in mind that if your will is not drafted in accordance with certain formalities, or if it doesn't include all of the assets in the estate, part or all of your estate will pass intestate through intestacy. A couple of practical tips here, just based on some experience. I think it should go without saying in the context of planning for art, but make sure that your art-related assets are specifically planned for. And I feel like this is a conversation that I need to have more and more often, because people are printing out template wills from the internet, and usually art is lumped into a category. It's typically called tangible personal property. And that's usually just a catch-all category that usually for the average person, it's like your desk chair and your IKEA goods, and it really is just not prioritized. It's usually just considered like the residue of the estate, not anything important. And of course, IP is usually entirely disregarded. It's like painful to think of all the times that art or like art-related assets literally end up in the garbage because they're not specifically accounted for, and that's just deeply unfortunate and horribly sad. This kind of dovetails into another tip that I typically recommend, and that's having an art or a cultural executor. Your standard executor, I mean, more often than not, it's, your spouse or another family member, someone who's kind of invested in your estate. And that person may or may not know how to work with art specifically. There's a lot about how to manage art at death that is incredibly complicated. If you're looking to sell art at death, someone needs to be familiar with how art is sold. And that's one of the hardest things that you can do, even for art professionals. Understanding the market, knowing who to go to, understanding the art market in general is just a can of worms. And knowing which auction houses may be appropriate, and if your estate is not at the level of an auction house, understanding the tools to do that are really nuanced. So we do recommend for certain situations that there be a person familiar with your practice and maybe the market for your work, who can take on those specific functions. And that it doesn't need to be someone who's dealing with the rest of your estate, although it can all be one person. You just want someone who's sensitive to your business as well as to the market that may have been received by. Sorry. Ultimately, I would say that whether who you appoint as an executor or who you appoint as a beneficiary, they should be made aware of what's happening. I'm going to say this many times throughout the presentation, so it's ironic that I kind of forgot about it, that it's really important, whether it's a will or any other vehicle, that you tell the beneficiaries what your plan is. I have a lot of conversations with people who suddenly this really beautifully intellectually crafted estate plan that they've generated starts to fall apart because they realize that their kids don't want it. Or maybe they can't take on 2,000 paintings in their home. And suddenly they realize that this entire legacy that they'd created in their mind is actually not going to work, practically speaking. And so I think it's really important in the construction of a healthy estate plan that you start having these conversations early on, and that you make contingency plans for if your kids don't want it and the Met doesn't want it, because those tend to be sort of the biggest things, is I'm going to leave it to a charitable institution, or I'm going to leave it to my family. And those are usually not the best ways to get rid of everything. It's a lot of work. I would also consider what happens to your unfinished work or archival material when you're thinking about all this as well. So moving on briefly to trust, there are a ton of different kinds of trusts out there. I work in the trust space as well. And so like I know everything I'm going to be glossing over and it's painful. I'm not going to get into the nitty gritty. But I would think of the creation of a trust as a creation of an entity that's overseeing what we call as a trustee for the benefit of one or more beneficiaries. At a basic level, the trustee's job is to basically run this entity, the trust, in accordance with the terms that you set forth in the trust agreement and of course with applicable law. Individuals will, transfer work to a trust during their lifetime or at their death. And it's really important to know why I think you're putting art in a trust, just as a best practice. It's really not the most flexible tool, I think, if you're not careful. But I think you really should consider why it needs to go into a trust instead of being managed in another way. We see trusts being used in a couple of situations, though honestly, in my practice, we're starting to see this less and less, which I'm not mad about. We see this really when an artist plans to hold their work over a period of time, usually so that it can be sold over a number of years and have the proceeds go to the trust for eventual distributions to the beneficiaries of their choice. And it's important to keep in mind that art is a really expensive asset to maintain. It's not like holding an Apple stock. There's storage expenses, maintenance expenses, insurance, appraisal costs, all of that. And it costs money just to hold art for a long period of time in a way that's proper. Usually those expenses are borne by the trust. And so it's important that the trust has a certain amount of liquidity to bear those costs over time. Most people will just stick art in a trust and then it can't support itself. And ultimately, art is usually either sold or it's distributed out to the beneficiaries and the whole thing just collapses. Furthermore, the creation of a trust, because it's a creation of an entity, except for some specific exceptions, the IRS reads that as the creation of a brand new taxpayer. So if you're creating a trust with art in it and there's income, so whether you're getting, maybe you have the IP rights that are generating royalties in there, or you're loaning out the art for cost, or there's other sources, the biggest mistake I see in that context is, again, not funding the trust with additional assets that can pay those taxes. So what will ultimately happen is that the art will need to be sold prematurely, and then the trust has bled itself dry because it can't sustain its own expenses. So like everything else, you need to properly capitalize. And that's why I don't see trust being used super well. Another vehicle that we've started to see, or that we've continued to see really, is called a CRUT, or any sort of charitable remainder trust. So if you're planning ultimately on donating your art to a charitable organization at your death, you may set up a charitable remainder trust now. Maybe the beneficiaries receive regular distributions. Again, that requires liquidity based on the fair market value of the trust. And then at the end of a term, the remainder, the art, will go to charity. Liquidity is really just the name of the game here. Similarly, we have artist endowed foundations. And I know I'm basically talking about death for an hour, but this is going to be really where I'm the killjoy, because artist endowed foundations and anything in this category really requires a lot of planning and a lot of liquidity, and that is often not considered throughout, when setting one up. an artist endowed foundation is a private nonprofit entity that manages your artistic estate for the public benefit. And so you're managing the artist's physical work, the IP, your reputation, all of that. You're creating like a trust, you're creating a separate entity. In this case, it's going to be tax exempt. It's going to be a 501c3 under the code. And it effectively owns your assets and manages them in accordance with a particular mission. They can be created by you, by your heirs, your estate. It doesn't need to be you, but depending on who wants to do it. And it's a really tempting solution, right? Because you're thinking it's tax exempt and it does exactly what I want. I want to have my artistic estate managed, and it sounds great. But getting 501c3 status with the IRS is incredibly onerous. It's very time consuming. It can take, I mean, I've seen it take years. The planning and the regulations involved might ultimately end up complicating the goals of what you want. And even if you do get it up and running, it takes a lot of work and is very expensive usually to maintain. I mean, really the most successful foundations that are created are usually capitalized in addition with the art and everything. So I said liquidity is usually capitalized with, a couple of $1 million. So it might be the great solution for some people, but it shouldn't be the default for everybody. I think over the course of 10 years, I've been approached by a lot of people who want to go this route. I've had one person of all those people maybe have it be a suitable solution for, and even they're considering whether it's worth it just in the context of the rest of their estate plan. It's just something to really, really think about. If you want to come up with sort of a more efficient, effective combination of other options, you can consider, from on the charity front, really donating work to charitable organizations. It's usually easier to develop relationships with an institution than it is to set up your own, is sort of what I would say. If I've said it once, I'll say it again. I would really encourage you to touch base with these organizations before leaving them as a beneficiary in your will. They are not compelled to say yes. And so if they say no and you don't have a contingency plan, just like I said, there goes your legacy with regard to those objects. So it's really best to just develop relationships over time and make sure that that's the right institution for your work. You can, sometimes finding, we've been seeing a lot more people explore leaving them to educational institutions, like their university museums and local organizations or organizations that really fit their niche. And you have, like I said, you want to work with them, make sure it's good, and then include it in your estate planning docs. For lifetime gifts, as I mentioned before, if you're going to make a lifetime gift to one of these organizations and you want to take a deduction, the tax deduction will only be available up to the cost of production, like I mentioned. So that's where keeping track of that is helpful. The fact of the matter, though, is that there's a lot of little rules about whether or not when you can take the deduction. Usually it has to be a related an organization that uses art to further its mission. So you want it to have a related use is what they call it. And the institution can't get rid of it in a 3-year period. At the end of the day, though, I find that artists are, and I hate to say this because it just feels like artists are being told you should do things for exposure all the time. But I think the fact of the matter is that there's a lot more interest in the cachet that comes with having your work at an institution than a tax deduction could ultimately get you. But it is something to keep in mind. Finally, we also consider gifting work and material during your lifetime. This is more of a pre-estate plan since it would occur while you're still alive, of course, but to the extent that it makes sense under the circumstances, it can sort of release the pressure if you know already where certain works want to go and the beneficiaries are already on board. I have a note here about the annual exclusion amount, which is currently set at $18,000 per year. That's the amount that you can give to any one person without triggering a filing requirement with the IRS. So if you have an artwork that's, $15,000 and you want to give it to your daughter, you can give it to your daughter no problem without having to file what's called a Form 709. If you want to gift over that, it may not necessarily trigger a tax, but you at least need to file that gift with the IRS. And that 18,000 applies to any one beneficiary. So if you have 6 kids, you can give $18,000 6 times, or a value of up to $18,000 6 times. That's where appraisals are going to come in handy. All of the other, records and materials that I told you before really come into play when you start doing this kind of planning. But this can also be an effective tool if you expect your estate to fall into that very large category of being subject to the estate tax. You can start to reduce the size of your estate in advance of your death. Alrighty. So finally, I have some best practices here about drafting an estate plan. First and foremost, really take the time to consider what legacy means to you specifically and how it reflects your priorities. There, as I mentioned when we first started, there isn't a one-size-fits-all approach here. There isn't one right way to define success. And you want to make, if you really care about the success of your family, maybe that's not the same thing as working overtime to get your work into a museum. There's so many little things that you really want to think about and different things that you have to balance. And, you just want to make sure that it's right for you. Usually there's a combination of solutions. And so just understanding what's available to you and starting those conversations early is really invaluable. I also have a note here about sort of striking a balance between defining your legacy and allowing for flexibility. I was sort of drawing this from what we call the dead man's reach in the trust and estates world, where there's really only so far that you, as a dead person, should be able to impact the future. The most successful estate plans are the ones that really make it clear what your intention is and are structured accordingly, but that also allow for flexibility because you don't know what the future is going to hold. And I think the classic example of this that has come up, in recent times has been, the Barnes Foundation, which, Dr. Barnes amassed this amazing Impressionist art collection. He wanted it held the way he wanted it. He was like, you can't move it from this mansion off, in the main line of Philadelphia. Nothing can be put on loan or just leave this estate. It has to stay here. And of course, it wasn't capitalized for the long term. So we talk about liquidity. And it put the art at risk and created a lot of other issues. And ultimately ended up in the courts for years. And, maybe our estates are not at that level, but that's the kind of tension that if you don't plan for the future and have contingency plans, you can have sort of your mini version of that. I also strongly recommend seeking out trusted professionals who have experience working in this space. There are scads of them out there, and they're all really happy to help. And if needed, there are plenty of them that also offer pro bono services. I think there are plenty of art attorneys out there, accountants who have an understanding of, art in this space. We've talked about the idea of art or cultural executors, and of course, working with qualified appraisers. Especially when anything hits the IRS's desk, you're going to want to make sure that you're working with all the right people, just so that things are sort of buttoned up and you're not running into sort of any audit risk with any of these items. Talk to your loved ones, your beneficiaries, and your fiduciaries about your plan. And I wish I could just say this every day. Like I said, you really want to have those. Sometimes they're uncomfortable. Maybe your kids just frankly didn't really care for your art, and there's some things they want to hold on to for sentimental value, but they don't want every version of something you've ever made. And you really want to think about how you can satisfy their wishes in a way that also doesn't leave you in the lurch because now they're going to, throw everything away or just give it to somebody. So I think understanding the reality of the situation is extremely important. I can't overstress the importance of open conversations. I've said it before, plan for both the physical works and the intellectual property. Intellectual property is very important for, long-term planning as well. So don't forget about that. I've concluded a note here about considering the specifics of your medium. So for instance, if you're a photographer, maybe you've made a print of a work, but now there's negatives. And what are you going to do with the negatives? Is someone going to be authorized to make additional works from those negatives? Same thing with, sculptors. If you have a cast, are you going to be able to, use those molds in the future, et cetera? Just considering all these different, the nuances of the exact medium that you're working with. And then finally, update your estate plan at major inflection points. Oftentimes that's going to be, if you get married, have children, get divorced, you'll kind of know it when you feel it. And if that's when in doubt, if things change, update it as soon as possible. And I know I've beaten this horse to death, but definitely liquidity. You don't want to get to the point where you've planned to make this perfect estate plan and then you realize that like you don't personally have enough money to pay off your debts and taxes, and then all this plan kind of falls apart because you still owe money, or if you're trying to fund a trust, or if you are lucky enough to be able to create a foundation, et cetera. Just this is kind of where the rubber meets the road in terms of being realistic and being practical. But I do think that so much of the grief that comes at death has a solution. I mean, obviously the death of a loved one is really, really hard, and we don't want to make it harder by having all these outstanding items. And I think it's really important to sort of take the reins while you can so that you can rest easy and your loved ones are left in the best possible position to carry on your legacy. So the sooner you start, the better. And if there are any questions, I'm happy to answer them at this time.
Thank you, Minerva. This was a great presentation, very informative. We have some questions from the audience. I'll start with Mr. Frank McClung. He's asking if you are not donating your art as an artist to a charitable organization and only gifting it to an heir, then what the total dollar threshold for your art value that you need to exceed to need a formal inventory and qualified appraisal for the IRS? Maybe Frank would like to open his mic to specify a little bit, and perhaps that was already answered in your presentation about the...
I don't think I got into the exact numbers. If you need to file an estate tax return, it starts peaking the IRS's interest at a value of $3,000. Usually, because most people, and maybe I'm misunderstanding the question, so please feel free to jump in. Because most people aren't filing estate tax returns, it's not an issue. So if you're bequeathing something at your death, it really only needs to start, like I said, it peaks the interest at $3,000 if it's being included on an estate tax return. Otherwise, that doesn't need to be necessarily concerned with. There's no really a huge concern there in terms of value.
Thank you. I've allowed Frank to speak if there's anything further he would like to ask or add. Okay, that helped. Thank you, Frank. From Sarah Johnson, we have two questions. You mentioned running your artworks and your business like a company, and she is asking, what about art LLCs for artists? I know they are popular for collectors.
Yeah, so I think there's sort of a lot of different reasons why you might have one, even if it's for your business. I think that's really helpful. Just also from a liability perspective, there's a lot of good reasons to have an LLC. If it's just you that's owning it, when you're thinking about like the business concerns and tax considerations, it's a pass-through entity, so it's not going to like change your tax situation all that much. But I think it is a good way to, like I said, it's more of a liability tool. Ultimately, LLCs have, books and records requirements and stuff like that. I mean, there's nothing that you shouldn't be doing anyway, but that's really, it depends on what is best for you. Art LLCs in the collector context are really, we really, in quotes, push for that, and they're trying to get investor status with the IRS. It's not necessarily about the holding of the art for any specific reason. But it's a good way to develop a separate books and records, which can be helpful in this conversation that we're having now.
Thank you. Her second question is, can an artist transfer the right to sign work, for example, new prints or of photos, after the death to an heir or a beneficiary? Would that have a taxable value at death?
Sorry, to sign?
Sign work, like new prints of photos.
Oh, I mean, I don't know about like the physical signature. I think that's probably not a good practice. However, you can have authorized reproductions. So for instance, if you are using negatives to reprint, they can be sort of official reproductions as opposed to someone printing out another picture and saying this is a, you know, a Minerva Pinto photograph. So that is a tool that is used posthumously as well. And yes, I mean, how those are valued in the marketplace is really up to an appraiser and how the work is doing. I don't know necessarily about the tax implications. It's just, I mean, that would really come around if it's sold. That's going to be, like I said, that may be a source of income, and it's a way to control your own market, which again is something to consider for, especially for certain mediums.
Great, thank you. Next question from Frank McClung again. He's asking, how much liquidity should you plan for annually to fund a trust for your art?
That is extremely fact dependent. It depends on the volume of art that's being held in the trust, and the needs of it. So it's one thing if, I mean, you have to consider storage costs, insurance costs, any sort of regular, if it needs to be appraised for whatever reason. That's something that if you have experience working, kind of already doing those tasks, you might be able to start to sort of back into that number. It's also a good idea to, I mean, in our practice here, for instance, we will invest proceeds or like sort of these sort of more liquid assets so that it continues to generate income and grow. And I think most, endowments and foundations work that way, for example. So just trying to find the best way to grow those assets in addition to making sure it's adequately capitalized for whatever volume of work. Trying to professionally store 1,000 works of art is very different than the cost of storing a couple. That's definitely a fact-specific determination, but you can usually kind of back into a good number. And you can also continue to add to trusts, like as long as, we kind of recommend that it be the same person, but if you create a trust, you can add additional assets if it's properly. So as long as you have access to that liquidity yourself, and you sort of talk with your attorney, just make sure it's all good. You should be able to add to that as well over time.
Thank you. Sorry, I was speaking with my muted microphone. Frank, thanks you as well. So next question by Henox Ships. Can you discuss a couple of best practices if an estate plan is in place and the artist has already passed? That is, if you are new to the relationship, is there an efficient way to obtain and review estate plan records as an appraiser, advisor, attorney, collection manager, and even someone in your position, etc.?
I mean, I don't envy the person in that situation, but I think ultimately understanding, and that's where I think the artist has a huge role, which is not the answer to this question, but this is exactly the kind of reason, this is exactly why you want to be prepared. You may have someone who's coming in, they've been appointed after the fact, maybe someone died, maybe, you have a new attorney in the mix. I think the best way to go about it is really understanding the landscape. I think this is where you kind of get into the human element, understanding where these people had touch points and starting there. I'm hoping that in this context, at least their documents are available to you, and that there is maybe some family around to provide some additional color. It's a very tough position to step into after the fact. I know I have, a few friends who are attorneys for artists' estates, and they have said it's probably one of the more emotional roles that they've held, where a lot of what you're working with is you're working with the family and the family's idea of legacy. Unfortunately, that's just part of the job. And kind of constantly having to interpret what the artist may have wanted in the context of what's better for the family. So my understanding, just based on other colleagues that I've worked with, has really just been get a handle on the documents and the actual facts of the matter, but that you're going to be mostly a lot of the work and a lot of the skill comes in when you're dealing with the families and beneficiaries. I have no idea if that answers that question. I'm just mostly really sorry that you have to deal with that.
Thank you, Minerva. These are all the questions I have in the chat. I have a personal question as well from my side. You mentioned that artworks need to be regularly appraised. I was curious how often that should be done. Is there a specific time set, or maybe in major life events? You mentioned that the artist death is not necessarily the best time to do any.
Yeah. I mean, that's going to be dependent on the situation. So for instance, if you're engaging in lifetime gifting, or if you're doing any sort of planning, putting things into trust now, I think that those are good periods to have art. I mean, those are actually required periods to have art appraised. I don't know. I mean, I think it depends. When you're just talking about like a regular appraisal practice, just given your body of work, it may not necessarily suit everybody regularly. I think if you're a practicing artist and you're established, that kind of will happen a little bit more organically as things are sold and traded. I know that we have certain, for insurance purposes, they're going to ask for regular appraisals. We have cases also in the trust context where, for instance, you need to make rental payments to the trust if you have the art on your wall. And so those appraisals we recommend having every, maybe 2 years. Um, I think it just very much depends on the nature of the estate and what is happening in their market. I don't think that the average artist needs to go out and hire an appraiser regularly for their stock, necessarily, unless there's some sort of specific reason um, necessitating that. I think especially it comes up in the insurance context, and then absolutely happens at various points in the trust and estate planning context.
Perfect. Thank you so much. I don't see any more questions on the chat. And as we approach 1 p.m., I want to be mindful of everybody's time. And so thank you so much, Minerva. Thank you, everybody, for your participating, for attending. We are very happy to see you here. We have sent out in the chat a link for your feedback survey. If you, we would love to have your opinions on how you think, what you thought about the workshop, if there are any topics that we should think about going into the future. And we will, as I said before, we will send out an email with all with the recording and all the materials in the handout. So thank you so much for joining us. I don't know if Minerva, you want to give us some final words or.
I think as I said, I think that the most important thing is to find the right solution for your specific needs. Everything. I hate to be the lawyer in the room that constantly says it depends, but that is the fact of the matter. And so I'm really excited that the center has clinics like the one they're about to put on, so you can start to sort of dive into the nitty-gritty of your specific situations. It's a really great thing that they do, and I hope everyone takes advantage of that.
Perfect. Thank you. Yes, we'll have a clinic on October 16th on legacy and estate planning. We will send out the details for that one shortly via email as well. We hope you were able to attend. On that note, thank you so much. We will stop the recording and